I'm a mother of 2 children from a previous marriage. My second child has cerebral palsy and I'm his full-time carer while my new partner goes out to work. I receive disability and carers allowance, and while my ex-husband is usually regular with his maintenance payments, his name is still on the deeds of the house we all live in. He wants his money from the house. He says that my partner can afford to take over the mortgage repayments. Where do I stand? So it sounds like this couple weren't married. Also, they weren't married, sorry. So there's effectively an element of looking at whether they can buy out their ex-partner. If they can, then that would be the ideal, to say, here's a chunk of money for their interest in the house and transfer it over. But if they can't, we may look at what's called like a mesher or a deferred sale. So it would be looking at what the child's needs is, whether the property is particularly adapted for them as well. If the child has had adaptations made to the property, then actually there would probably be a good case to say that it doesn't need to be sold at the moment, especially while they're in the minority. It would look at what that child's circumstances. Ultimately, everything is based on what's best for the child.
Yeah.
So if they are under 18 and they're going to a school in a local area, the court would be very reluctant to force a sale of a house that's going to mean a child may have to leave a property that's been adapted, or they may have to go outside of an area where they're familiar. So we would look at the circumstances of the new partner. Could they go on the mortgage? Would that increase the borrowing capacity? But also the other element of that is, does that person feel ready in their relationship to commit with their new partner to add them onto the mortgage? And if they were, then we'd have to go down that road again of things like prenuptial agreements or cohabitation agreements. Because if there is equity that they've accumulated from their first marriage, then we need to make sure that if their new partner's going to go on the property, that they are protecting what they've already built up beforehand.
Yeah, and from my perspective, I'd be talking to the client about their child that has cerebral palsy. Again, if they wanted to make provision for them in their will, they can set up something what we call a disabled persons trust, because that child might not be able to manage a large chunk of money. It could affect any benefits they may be in receipt of, and they might in their will set up that type of trust. And actually, there's certain better tax implications to those types of trusts as well. So I'd be talking to the client about making sure they provide provision for that child that has cerebral palsy in particular. I'm a father of 1 boy, divorced from his mother and currently single, living in my own place. Earlier this year, I inherited a house and assets from my parents. I intend to move into the house, but I want to safeguard what I have for any son. How best can I do that? My ex-wife doesn't have any claim on my inheritance, does she? Okay, so from a private client perspective, if you are divorced, so there's something called the Inheritance Provision for Family Independence Act 1975, we call it the 1975 Act, which says that certain people can contest a will. So if he makes a will and he leaves the ex-wife out, it's unlikely she's going to be able to succeed in contesting it, because she's not listed as one of those people. She's not a spouse. She hasn't lived with him for a certain period of time, etc. No longer a spouse. However, am I right in thinking it might depend on what's in the consent order? Because sometimes when I see clients and they're going through a divorce, I ask to see the consent order, and often that's where we overlap, and I ask you to have a look at it, because I want to make sure that he's providing provision obviously for his son, but he's not doing something that goes against the consent order that might say even when he passes away, needs to continue to pay maintenance or something like that towards the son, or they might not have had what they call a clean break. Is that right?
Yeah, the clean break's going to be essential here, because ultimately ending the marriage and having the divorce, even the final order, doesn't end a financial claim. So what you need is that clean break element. That's effectively what closes the door on your ex-partner being able to make a financial claim. If you don't have that clean break element, or even if you don't have a financial order, even if the divorce is finished, they could still come back and say, well, actually, this is still an asset, and I will potentially try and make a claim on that. The reality is if it goes in front of a judge, the court will look at the assets at that point in time. So although they will give consideration to assets that have been accumulated post-separation, the court do have the power to deal with any assets, whether they came into existence before, after, or during the marriage, and potentially put a claim on there. So certainly the clean break element is going to be the key part, because that's what's going to make sure that whatever they've got remains with them and their ex-partner can't claim on it.